Hello and welcome back to the course on Indian polity. We have completed part 1 and part 2 of the Indian Constitution, and today we begin our discussion on one of the most powerful and transformative parts of the Indian Constitution. That is, of course, the next part, part 3rd, which talks about the fundamental rights. These rights form the very heart of our democracy. The rights defines the relationship between the state and the individual and ensure that every person in India enjoys dignity, liberty, and equality. Fundamental rights are not just legal provisions, they are moral commitments that protect citizens from arbitrary action, discrimination, and misuse of power by the state. Inspired by the ideas of freedom movement across the world, and shaped by India's own struggle for independence. These rights guarantee essential freedoms such as the right to equality, right to life and personal liberty, freedom of speech and religion, and protection against exploitation. Part third also establishes the framework for judicial protection through remedies like Article 32, often called the heart and soul of the Constitution by Dr. Bhimrao Ambedkar. Together, these rights make sure that India does not just remain a democracy in structure, but also in spirit. So let us start the discussion of the fundamental rights, that is part third. But before we go deeper into the articles of the fundamental rights, part third of the Indian Constitution, starting from Article 12, we shall first try to understand what are the different rights that as a citizen we can avail. So the rights can be broadly categorized into the constitutional rights or the statutory right. When we say the constitutional right, it itself means that the right is mentioned in the constitution. So let us discuss first the constitutional right. When we say the constitutional rights, that means these rights these rights are mentioned in the constitution. That is from where these rights derive their authority. They derive the authority or power from the constitution. They derive the power from the constitution. So power is backed by constitution. They derive the power from constitution. So now, Constitution, as we know, already has more than 470 articles, and within that, it has been categorized into different parts. Specifically, when we talk about part third, the rights mentioned in it is termed as the fundamental rights. Fundamental rights. So, if we call that are fundamental rights constitutional right? Yes, because they are mentioned in the constitution. So, specifically, if we talk about the right mentioned in part third of the constitution, then we call that as the fundamental rights. Rights mentioned elsewhere, such as right to property mentioned under 300 article number 300A. So this is also mentioned in the constitution but is not mentioned under part third of the constitution. Therefore, this is not the fundamental right but the constitutional right. Now, why we are emphasizing the term fundamental rights and the constitutional rights? Because both the rights derive their authority from the constitution. But when we go through the part third and the articles, as we mentioned in the beginning, that Article 32, which is contained in the part third of the constitution, itself provides for the constitutional remedies. What do we mean by the constitutional remedies? We will discuss this, but let me give you a brief introduction over here itself. Constitutional remedy means if your fundamental rights are violated, that means if you are not enjoying the fundamental rights or somebody has violated your fundamental rights or deprived you of your fundamental rights, in that case You need not to wait for the lower court, or you need not to go to the police station to file a case. You can directly go to the highest authority in the country, that is the Supreme Court, which is known as the Supreme Protector of Right and Supreme Protector of Right and Interpreter of the Constitution. So directly you can go and file writ petition. Petition means an application, and writ is a special type of application which can be filed before the Supreme Court in case your fundamental right is breached or you have been deprived of. So that is why fundamental rights are contained separately in the Constitution as a part third of the Constitution. Whereas the right mentioned elsewhere in the Constitution, maybe example is of 300 Article 300A, then such rights are constitutional rights, but not the fundamental rights. So we can say that these rights can't, fundamental rights are can't be, this right can't be taken away by the state, can't be taken away by the state. Nobody can deprive you of, nor the state. The state means neither the government nor any other citizen can deprive you of the fundamental rights. So the fundamental rights are fundamental in nature. Why it is called the fundamental? Because these rights are very essential. Why it is essential? It is essential because it ensures the all-round development of the individual. Fundamental right ensure all-round development of an individual, and therefore these are known as the fundamental right. Fundamental rights, these are very fundamental for an individual for their all-round development. So originally there were total seven fundamental rights, but already we have discussed in the previous video the Keshwananda Bharati case, and after which the 44th amendment was done, and in which the seventh fundamental right, that is right to property, Article 31, was repealed from the part third, and it was mentioned elsewhere in the Constitution as Article 300 Clause A. So as of now, we are having six fundamental rights. What are those six fundamental rights? Briefly discuss, these are right to equality, right to freedom, right against exploitation, right to freedom of religion, right cultural and educational rights, and right to constitutional remedy. So we will discuss all these rights one by one. So the one category of rights are the constitutional right that is mentioned in the Constitution. The other category of the right are the statutory rights. What are the statutory right? What do you mean by statute? Statue of Rome. Have you heard of about it? Go and find it out. What is the Statue of Rome? The statutory rights. When we talk about the statutory right, it means the right which is granted to you by an act of parliament. Granted by an act of parliament. Either the parliament has made the law or the legislature, state legislature has made the law. Okay. The rights which are granted by the act of the parliament or the state legislature are known as the statutory rights. So, do we enjoy any statutory right? Yes, we enjoy many statutory rights which were not mentioned in the constitution, but a law was framed by the parliament or the state legislature, and the rights were mentioned. So, what was the right? For example, we have the consumer right, we have the consumer right, and we are well aware of the consumer right under the Consumer Protection Act. Then the very famous right to information is a statutory act, right under Right to Information Act, RTI Act. Then we have the right to vote. Voting is not a constitutional right. It has been mentioned under Representation of People Act, RPA Act, Representation of People Act 1951. So these are the rights. We have rights. Everybody votes. We have voting right. So these are the statutory right. Right to information. We have consumer right. All these rights are are statutory right because they derive their authority. They derive their authority They derive their authority from the statute. Statute means law and not from the constitution. So I hope it is clear the difference between the constitutional right and the statutory right. Basically, statutory rights is granted to you by making some law by an act by parliament. Law may be passed by the parliament or the state legislature. They pass a law and grant you the right. For example, tomorrow there may be a law in which it may be said that right to say suppose just for an example, right to drink water is a fundamental right and you should not be denied the drinking of water. So there may be an act passed by the government that tomorrow nobody will sell water for money. Everybody has to give water free because drinking access to free water is your right, not fundamental right, is a right under an act. So that would be the statutory right. Fundamental rights are the part of the constitutional right specifically mentioned under part third of the Indian Constitution. Hope that's clear the difference between the constitutional rights and the fundamental rights. Now, there is another category which sometimes may appear in examination, and that is the legal rights. What is called the legal rights? Legal rights means are those rights which are result of an agreement, law, or legal document or contract, anything. Legal document or contract. For example, we two party A and B comes in mutual contract, which is a legal contract, and it says that B will have the right to view all this document and B has said that, and A will have this right to do this. So all this right that has been granted to A and B through a legal contract or a legal document are legal rights. So we have discussed three types of right: constitutional right. Within constitutional right there could be a fundamental right or other constitutional rights, and then we have the statutory right, and then we have the legal rights. So now let us move ahead and let us discuss what could be the property of the fundamental rights. What could be the property of fundamental rights? For example, say suppose there could be some rights. Or before we discuss that, let me explain you something uh, which is related to Indian citizen. Who are Indian citizen? We have seen in the previous video under part 2 of the Indian Constitution, which talks about the citizenship, who are the Indian citizen. Those individuals who are not Indian citizen are called as foreigners or aliens. Let us call it aliens. Okay. Now, with among the aliens, there would be some member. I'm calling aliens. That means you can call it alien or non-citizen. Those who are not the citizen of India. So those who are not the citizen of India can be broadly categorized into friendly friendly aliens or enemy aliens. Who are enemy aliens? Enemy aliens are those individuals who are not the citizen of India and are the citizen of enemy country. You do not belong to India, you are not a citizen of India, but you are a citizen of a country with which India is at war, or the country which is the enemy of India. For example, we say that India is always at war with Pakistan. So the citizen of Pakistan, when they visit India, they will be treated as enemy aliens and they will be deprived of some right. For example, we have right to life, that everybody have right to life and live with dignity. So these categories of right, there are some categories of the fundamental rights which are available to all person, irrespective of their citizenship, whether they are Indian or they are foreigner, I mean alien, or they are enemy alien or they are the friendly aliens. There are some categories of the fundamental right which are only available to Indian citizen explicitly, while the others are only available to the friendly aliens and not available to the enemy aliens. As we proceed with this lecture, we will able to figure it out. What are the rights that are available to aliens? What are the rights available to enemy aliens? And what are the rights that are available to Indian citizen? So for Indian citizen, all the rights are available. The only difference we have with the enemy aliens and aliens. So just copy it down. We will discuss the thing as the video proceed further. Just write it down. The articles for aliens, the Article 15, Article 16, Article 19, Article 29, and Article 30 does not apply. This is for aliens. Those who are not the citizen of India, they do not claim that the fundamental rights are not available to them. What is the Article 15, 16, 19, 29, and 30? We will see. It's talk about equal opportunity in the government offices, talks about reservation and all that thing. We will see in the coming time. But just note it down that this Article 15, 16, 19, 29, and 30 are not available to aliens. And if we talk about the enemy aliens, the list will be further longer. That is, apart from these right, obviously all these right are not available to alien. That means these are not also available to the enemy aliens. Let me explicitly mention it over here that Article 15, 16, 19, 29, and 30 is not available. Apart from this, Article 22 clause 1 and 22 subclause 2 are also not available to enemy aliens. Just note it down, keep it somewhere safe. When we proceed with this, we will understand this article. You will come to recall that, okay, why these articles are not available to the enemy aliens and aliens. So now quickly let us see what are the features of the fundamental rights, and then we will discuss the article, first article of part third of the constitution, that is article number 12. So some rights are only for the citizen while other are for all person. When you go through the article, it will be written in, they will be mentioned that the state shall not discriminate. See, here it is mentioned that the state shall not discriminate against any citizen. Clearly mentioned that this right is available only for the citizen and shall not discriminate against any citizen. While some of the fundamental right, it is mentioned that the state shall not deny to any person. So here it is mentioned at person, at some right is available to all the persons, some right only available to citizens. So the point number one, which says that the some rights are only for the citizen, while other are for all the persons. And what are those rights which are available only to the citizen of India? Are right apart from this right, there's apart from the article number 15, 16, 19, 29, 30, all the rights are exclusively mentioned for the Indian citizens only. So, the Constitution confers the following rights and privilege on the citizen of India and denies the same to the alien that we have discussed. Article 15, 16, 19, 29, and 30. These rights are not these rights are not meant for the aliens. Only and exclusively these rights are applicable for Indian citizens only. So see article number 15. What does it say? Rights against discrimination on ground of religion. No discrimination on the ground of religion, race, caste, sex, or place of birth. That means you can discriminate these foreigners, not the Indian citizen, on this ground. Therefore, if you have went through to any monument, Indian monument place such as the Red Fort or anywhere else, you see there are two different ticketing price. One for the Indian, that is 10, 15 rupees. Another for the foreigners, which is 20, 25, say 250 or 300, something like that. So the rights, they can be discriminated on this ground. The discrimination on grounds of religion, race, caste, sex, or place of birth is only meant for whom? The Indian citizen. So article number 15, 16, 19, and 29 and 30 are only and exclusively meant for the Indian citizen. These are not available for the aliens. So what does article 16 says? Right to equality of opportunity in the matter of public employment. Article 19 says right to freedom of speech and expression, assembly, association, movement, residence, and profession. Article 29 and 30 say their cultural and educational right. So whatever I have written over here, those right, you can just, if you want, you can write the details of that. Otherwise, we will also discuss as we move further. Right to vote in an election in the Lok Sabha. These were the fundamental rights that I talk about. These fundamental rights are not available to the aliens. Other right other than the fundamental rights are right to vote in the election, not available to the aliens, only available to the Indian citizen. Right to contest for the membership of parliament and state legislature. See, this you can write this. This is a valid point. But when we talk about the eligibility condition to become the member of the parliament or state legislature, it should be the Indian citizen. That is the first. You should be an Indian citizen. That is the first eligibility. So automatically, you are not eligible to contest to become the member of parliament or state legislature. So you cannot contest. You do not have the right to contest. Okay, because you did not meet the eligibility criteria. Okay, next point, eligibility to hold certain public office, that is the President of India, Vice President of India, judges of the Supreme Court, High Court, governors of the state, Attorney General of India, and Advocate General of India of the state. Because all these posts, when we see them individually, we will see the first eligibility to become this to hold this post is that you should be an Indian citizen. So even if you do not remember all this point explicitly, the eligibility criteria will automatically apply. So right to vote also, to election, you cannot vote in election if you're not an Indian citizen. So these are the rights which are only meant for the Indian citizen. Just remember the article. Moving forward, fundamental rights are not absolute. What do I mean by this? They are subject to reasonable restriction. So we say that we have freedom of speech and expression. We have freedom of speech and expression. So this the absolute right? Means I can enjoy this right in its fullest without any restriction? No. Every fundamental rights comes with certain restriction. You cannot speak anything against the law and order of the country. That means you should not infuriate someone to commit violence against the country. The unity and integrity of the nation should not be kept at danger by your speech. The relationship of India with any other country should not get tampered by you while you are exercising your freedom of speech and expression. So there are reasonable restrictions. We will see each restrictions when we go one by one through all the fundamental rights. Then some of the rights you enjoy against the state and not private individual, and some rights are against the private individual and not against the state. For example, if the government violates the right, you can approach the Supreme Court or High Court for the writ remedy. And if a private person violates such right, only ordinary legal remedies are available. What does this sentence mean? That means most right protects individual against the state. If you go through the articles, you will see the state shall not, the state shall not. These are things are mentioned. That means it is the prohibition or privilege to the state, not an individual. So if you want to sue someone that these are my rights, who should give you this right? This right should be given by the state. How do you know that? Because in the article it is written that the state shall or the state shall not. So the state is responsible for this. So I should sue the state. Where would you sue the state? I would sue the state in the highest court of this country, that is the Supreme Court. Okay. If somebody discriminates you, if I am a private individual, I discriminate you. For example, I have two chocolates. I give you one chocolate. The other person I did not give him because I say that you are not, say, suppose you are from a particular religion. I will not give you the chocolate. So, am I violating a fundamental right? No, your right to be treated equally, to not be discriminated, is against the state. The state shall, while distributing something, while offering a seat, shall not discriminate between the people belonging to two different religion. But as a private individual, if I am discriminating, that means I am violating some laws if there are. So I should be taken into the remedy available in the law. For example, See, prevention of atrocity against SC and ST, there has been a law. Okay. If somebody violates the fundamental right, like if it is not the state, if some individual, if you feel that some individual is violating a fundamental right, you cannot go to the Supreme Court and say that this that thing is happening to me. You can only apply to the local remedies available. I hope you're getting to the point. That is, if a private person violates such a right, that is your fundamental rights, which is guaranteed against the state. The article clearly mentioned the state shall or the state shall not. And if such right is violated by any private person, only ordinary legal remedies are available. See, most of the question is getting to be asked from what I am discussing in this video. In the upcoming videos, I'll be straightforward, directly talking about the different articles and will explaining the terms used in the article. But see, this before the going into this article, the preview, the background is very important, and what I am discussing in this video is most important because this is the concept related to the fundamental right that you should be aware of and you should know very well. Moving forward, point number four says some rights are negative, that is, it is restricting the power of the state, and some rights are positive, that is, it oblige the state to act. And we have already seen this. What I have taken is nothing but directly I have taken a snap of the constitution. If you have the constitution with you, the PDF version, look at it. In that snap, there are the state shall not, these are the term used. The state shall not, under the part third of the Indian Constitution. That means it is prohibiting the state. It is prohibiting the state. You shall not. The state shall not. The state shall not discriminate. So these are the negative restrictions on the power. These fundamental rights can be considered as the negative fundamental rights because they put restrictions on the power of the state. But see the next right, the state shall provide right to education. The state shall provide. That means it is obliging the state that you should provide. It is felicitating the state. You should do this. That means these are the positive fundamental rights. So some rights are negative, that is restrict the state power, while others are positive, that is oblige the state to act. For example, state shall not discriminate, Article 15, Clause 1. No person shall be deprived of life except by law, Article 21. Wherever we see that shall not or shall be deprived of something negative, that is called as negative right. Positive right means require the state to take action. The state shall do this. For example, right to education, Article 21A requires the state to provide schooling. Article 32 requires court to enforce rights. So these are called the positive fundamental rights. So I hope few points are very clear. What are the rights against whom you can apply? You can go to the court. So the rights are protected against the state. Okay, the rights are positive and negative in nature. True or false? True. The rights are not absolute. They are subjected to reasonable restrictions. True or false? True. Moving forward, the term is used, they are justiciable. Well, we were discussing the preamble. You remember we said that the preamble is not justiciable. That means you cannot directly go to the court and say that the preamble has not been enforced. But with respect to the fundamental right, these are justiciable, meaning you can directly approach the Supreme Court, file a special type of application known as the writ petition, and you can enforce the right, or the Supreme Court will enforce the right if it is being violated by someone or if you have been deprived of. So, for example, if current in the current scenario, let's talk about that right. Freedom of religion is a fundamental right. If tomorrow a state does not allow you, how the state will not allow you? They will make some law, some legislation, or some notification, some order they passes that tomorrow, from tomorrow, nobody is going to worship in the temple, or nobody is going to church or mosque or whatsoever place of worship you prefer. You can directly go to the Supreme Court, present the order, the Supreme Court, my lord, following state, so and so state, or so and so organization, or so and so has passed this order, which prohibits me, which deprive me of my fundamental right to freedom of religion. The Supreme Court will declare that order null and void and say and would allow you to exercise your fundamental right. So these are justiciable. That means a person can approach the court for the enforcement whenever they are violated. For example, if you detain someone illegally, it can be challenged through a writ of habeas corpus. What do you mean by the writ of habeas corpus? It's a special type of application. We will discuss different writ, then we'll come to know the detail about it. So the point to note over here is these are justiciable and enforceable by court. Okay, these are justiciable. Then the next point is they are not permanent or sacrosanct. Now, is fundamental right? We have already discussed this thing. Let me ask you the question on it. They are not permanent or sacrosanct. Can we nullify the fundamental right? Can we why can somebody change the fundamental right mentioned in the constitution? And yes, we have discussed this point sufficiently when we discussed the Keshwananda Bharti case, wherein we have discussed the Article 13, clause 3, clause 4, and the judgment of the Keshwananda Bharti, where it says that the fundamental right can be changed or modified only by the constitutional amendment, but you should not disturb the basic doctrine. So, yes, Parliament can curtail or repeal the fundamental rights, but cannot be done by the ordinary legislation. It can only be done by the constitutional amendment and not by the ordinary law, and without damaging the basic doctrine structure. They can be suspended, fundamental right can be suspended, but they can only be suspended during national emergency. Now, the question here arises, do all the fundamental rights get suspended during the national emergency? No. The right under Article 20 and 21 does not get suspended even during a national emergency. So there might be a question, which articles or which fundamental right do not get suspended during national emergency? That is Article 20 and 21. Let me give you a funny example. Let's say suppose कि नेशनल इमरजेंसी लगी हुई है वे विल डिस्कस द थिंग नेशनल इमरजेंसी ऑन व्हाट ग्राउंड इट विल बी इम्पोज्ड फॉर एग्जांपल लेट्स से सपोज कि जंग छिड़ा हुआ है इंडिया पाकिस्तान के बीच में या किसी भी कंट्री के बीच में इंडिया एक तरफ पार्टी है और बहुत ही टेंस सिचुएशन है नेशनल इमरजेंसी लगी हुई है पूरे देश में नेशनल इमरजेंसी के टाइम पे आप सुप्रीम कोर्ट जाते हो और बोलते हो कि सर मुझे यहाँ पर प्रार्थना करने का मौका नहीं मिल रहा है ये मेरा फंडामेंटल राइट है सुप्रीम कोर्ट बोलेगा कि बेटे देश का कंडीशन ऐसा है लोग मर रहे हैं ठीक है हमें देश में इमरजेंसी लगी पड़ी हुई है हम वॉर में हैं और आपको अपने पूजा वाली फंडामेंटल राइट वर्शिपिंग की फंडामेंटल राइट फ्रीडम ऑफ रिलीजन को एक्सरसाइज करना है और उसके लिए आप कोर्ट आए हो आपको पता नहीं है कि जब इमरजेंसी लगती है द टॉप प्रायोरिटी इज गिवन टू द कंट्री इवन द फंडामेंटल राइट इज सस्पेंडेड अभी हम कुछ नहीं कर सकते जब तक देश में नेशनल इमरजेंसी लगी है आवर हैंड आर टाइड टू आवर बैक यस देन इसका मतलब ये हुआ कि आर्टिकल 2021 क्यों नहीं इन्फोर्स होता है बिकॉज आर्टिकल 21 talks about right to life even national emergency is enforced in the country. Nobody has the authority to kill you, to shoot you, or to take your life because the right to life is the fundamental right, and the Article 20 and Article 21 remains protected even during emergency. So this point is important. I hope you understand that only two fundamental rights that is under mentioned under Article 2021 does not get suspended during emergency, while all other fundamental rights are suspended during national emergency. So national emergency, I'll discuss that's a different topic. Just remember then I'm going to skip the point number 8. I'll explain you in a meanwhile. Let us move to point number 9 and see that most fundamental rights are self-executory, meaning you do not need a backup plan. You do not need a law to enforce your right. Most of the rights are self-executory, means you do not need, you automatically exercise it, meaning they can be enforced directly. A few rights need a law made by the parliament to become operational. For example, Article 35 ensure national uniformity. Example, protection against human trafficking, Article 23, it is self-executory. Untouchability, Article 17 requires law, that is Protection of Civil Right Act 1955 was passed to enforce the fundamental right, that is untouchability. What is untouchability? You practice छुआछूत वाला चीज तो इस चीज को इन्फोर्स करने के लिए कि कोई प्रैक्टिस ना करे प्रोटेक्शन ऑफ सिविल राइट एक्ट 1955 लाया था मोर और डिस्कशन ऑन इट इज येट टू कम just giving you the important points from the examination point of view. I hope we have discussed the things. That is, some fundamental rights are self-executory, while other requires the law to be enforced. Note that point. Then we have the point that the rights which are suspended during the national emergency, that is all the right except Article 21, 20, and these are justiciable, they are not permanent and can be changed by the parliament by making a constitutional amendment. To what extent the constitutional amendment can be done, and what are the basic structure doctrine that we have already discussed. So this was all to give you a background about the fundamental rights. What are the properties is fundamental right? What we say that these are the fundamental right is they are sacrosanct and cannot be altered, or the fundamental right comes without any reasonable restrictions. All this thing you should know. Now, the fundamental right, as has been glorified so much, has been copied from the United States of America, but they have been modified to suit the Indian context. And we will see as we go on and proceed to the articles of the Indian constitutions, of the part third of the Indian constitution. We will see what are the depth of each article. So as of now, how many fundamental rights you can enjoy? We can enjoy. There are six fundamental rights that we enjoy. ओके, बस छह ही फंडामेंटल राइट्स। अब देखो, अब ये छह फंडामेंटल राइट्स सुनकर के ऐसा लग रहा हो कि क्या इतना बड़बोलापन है कि हम कहते हैं कि इंडिया का संविधान जो है वो वन ऑफ द बेस्ट कॉन्स्टिट्यूशन इन द वर्ल्ड है, लेंथीएस्ट कॉन्स्टिट्यूशन ऑफ द वर्ल्ड है। फंडामेंटल राइट्स बस छह ही दिए, 470 आर्टिकल्स हैं, मोर देन 470 आर्टिकल्स है, बस छह ही फंडामेंल राइट्स है। तो यहाँ पर आई विल से वन फेमस डायलॉग कि रुको सबर करो। द थिंग इज दैट these six fundamental rights is not just six fundamental rights. You know, as from the date of the adoption of the Constitution, that is November 1940, till now, these rights are ever evolving. They incorporate multiple rights in it. As we proceed through, we see the various rights that are embedded under Article 21, Article 19, etc. So these are categorized under six core fundamental rights, but as the supreme law protector of the country, that is the Supreme Court, has embedded it, or we can say has related other rights as the fundamental rights. That is the part of all these fundamental rights. You are getting confused? Let me explain to you. Article 21 says you have right to life. Now, it's upon us to think what does right to life means. Right to life is a fundamental right, but what does it include? So, if we ourselves interpret it some way, will it have any effect? No. But the final interpreter of the Constitution is the Supreme Court. If they interpret something, then their word is sacrosanct. Their word is what we say as the law that has to be followed. So Supreme Court from time to time had said that right to live with dignity, right to die with dignity is also a fundamental right. Right to use internet is also a fundamental right. There are multiple things that from time to time the Supreme Court has in various judgment said that these all are also fundamental right. Because why? Because they are derived from the core six fundamental rights that we will go to discuss in a moment. But before that, let us discuss Article 31 before it was repealed by the 44th Amendment Act of 1978. That is after the judgment came from the Keshwananda Bharti case. So Article 31 getting struck off from part third of the Indian Constitution, leaving six core fundamental rights. So thus, what does the Article 31 says? Article 31 was basically two part. 31 clause 1, we say that no person shall be deprived of his property except by the authorities of the law. And Article 31 clause 2 says that the compulsory acquisition must be compulsory acquisition must give compensation. That is a fair compensation. If somebody is acquiring your property, you must be given a fair compensation, and nobody can deprive of your property. You have right to property. Unfortunately, I have discussed this several times that after the enforcement and enactment of the constitution, there was huge disparity, land reforms were to brought in, and therefore this right was very difficult for the citizen to for the court to protect this right, and therefore modification in the constitution was done, and Article 31, subclause 1 and subclause 2 with its entirety, entire Article 31 was removed, struck off from Part 3, and it was no longer remained as the fundamental right. Why? Because if it is a fundamental right, the citizen has the option to go to the to go to the Supreme Court and then claim their fundamental right. So, to avoid such legal cases, such legal applications for the exercising of the this fundamental right, the Article 31 has been repealed from the Indian Constitution. And we have discussed the entire background of this in the video in which we are talking about the Keshwananda Bharati case. Now let us see the why here it is saying that the scope of the scope is limited by Article 31A, 31B, and 31C. So 31 clause 1, 31 clause 2 is different, and remember this is 31A, 31B, 31C. When the Article 31 was repealed, before that 31A, 31B, and 31C were added. So let us now discuss 31A, 31B, and this is one of the most important topic that we are going to cover in the fundamental right chapter. See, before we proceed with the with this explanation, let me give you a brief introduction to directive principle of state policy (DPSP). For DPSP, that is the part 4 of the Indian Constitution that we will be discussing in the coming video. Just to this point, let me tell you that DPSP were equally important as the fundamental right. But since the condition of the India as a nation was not so strong, and India was not in a position to enforce all the DPSP or all the provision that were mentioned in the DPSP. So they decided to keep it in a different in a different chapter or a different part of the Indian Constitution and name that as DPSP rather than fundamental rights. Why? Because if all the provision mentioned in the DPSP were kept in the part third as the fundamental right, then everybody would go to the Supreme Court and say that this should be enforced, this should be enforced, this all articles should be enforced, but the condition were neither economically uh, fine nor the widespread inequality and widespread the diversity allowed the makers of the Indian Constitution to make the provision contained in the DPSP into the fundamental right. So they were kept separate, but these provisions are equally important but are not justiciable. We will discuss about DPSP in detail, but let me just read some of the articles mentioned under the DPSP. So DPSP state that the state shall strive to promote welfare of the people by securing the and protecting the protecting as effectively as it may a social order in which justice, social, economic, and political shall inform the institution of national life. Then you see the state shall in particular strive to minimize inequalities. Then Article 39 says certain principles of policies to be followed by the state, and particularly 39A says that citizen men and women equally the state shall in particular direct its policy toward securing that the citizen, men and women equally have the right to an adequate means of livelihood. 39 clause B said that the ownership and the control of the material resource of the community are so distributed so as to best subserve the common good. Then it says is that the operation of the economic system does not result in the concentration of wealth and means of production of the common detriment. So, if you read this, there are multiple DPSP provisions. We will go to it later. But reading a few, did you get an idea that what this DPSP is actually trying to achieve? They are trying to achieve parity between rich and poor. They are saying that, see, this, they are saying that all the men and women equally have right to an adequate means of livelihood. All must be given jobs so that they can earn, they have an adequate means of livelihood, they should be provided some sort of job. So then in the next parts you see it's saying that the ownership and control of the material resource of the community are so distributed so as to best serve the common good. Then it says that the economic system does not result in concentration of wealth. मीन्स कि कुछ लोग अमीर नहीं होने चाहिए, सब बहुत ज्यादा लोग अमीर होने चाहिए। कंसंट्रेशन ऑफ वेल्थ, इकोनॉमिक सिस्टम ऐसा काम करना चाहिए कि वेल्थ कुछ लोगों के पास ही एक्यूमुलेट ना हो जाए, बट इट शुड बी डिस्ट्रीब्यूटेड, सबके पास होने चाहिए। बट अगेन यू सी द प्रोविजन जो डीपीएसपी में हमें बता रहा है, ये प्रोविजन एक कॉमन गुड की बात कर रहा है ना, जहां पर कंसंट्रेशन ऑफ वेल्थ नहीं हो, ठीक है, ओनरशिप एंड कंट्रोल ऑफ मटेरियल रिसोर्स ऑफ द कम्युनिटी डिस्ट्रीब्यूटेड हो, किसी एक बंदे के पास में ना हो। लेकिन इज इट नॉट इन कॉन्ट्ररी टू ऑन टू द फंडामेंटल राइट्स? फॉर एग्जांपल लेट्स से सपोज कि मेरे पास एक बैकवर्ड कम्युनिटी है जो बहुत पुअर है, मेरे पास एक बैकवर्ड कम्युनिटी है, लेट्स से एससी और एसटी। The history says that what were the conditions of SCs and ST, will not discuss that, but say that if these are the backward community, so in order to achieve whatever is said in Article 39 clause B and C, that concentration of wealth should not be in the hand of few, what we need to ensure? We need to ensure that the ownership is distributed. So if we want to promote this community, especially we will have to make some law which will ensure that the promotion of these backward communities are brought up. So suppose that in the history also, the some government started passing the laws. For example, in Mysore, an act was passed which was known as the Mysore Land Acquisition Act. Land Acquisition Act. This was an act which was passed, and it was mainly land reform act. So those zamindars and those landowners whose land were taken away, they simply went to the Supreme Court and said that, sir, this is the clear-cut violation of my right to property and I should be protected. Supreme Court will obviously, their hands are tied back again. Why? Because their duty is to ensure that the constitution provisions are followed. So obviously they will struck down this act. They struck down this act as well. They said that no, you cannot pass such law which abrogates, which overrides, which do not obey the provisions of the constitution, and especially if it is violating the fundamental rights of the citizen. So now the question arises, what should be done? At one hand, the fundamental right says the citizen will have right to equality. On the other hand, if I provide equal opportunity, for example, if I provide the equal opportunity, for example, I have 10 jobs, and in 10 jobs in the government offices, the right to fundamental right to equality says that I should provide the equal opportunities to every citizen of the country, irrespective of caste, religion, sex, place of birth, etc. On the other hand, Article 39 says that the ownership or the control or the wealth should not be concentrated in the hand of few. I have to serve the common good. But if out of 10 people, out of the 10 vacancies, I am opening the door open to all, these 10 vacancies are filled up by the peoples who are already having the wealth or already at the higher position. So, in this scenario, the common good is not being achieved. So, if I make some law, for example, these 10 offices, I will give some reservation that out of 10, 6 offices will only be applicable, will only be eligible to the candidate belonging from lower caste, for example, say SC and ST. But that would be clear-cut violation of the fundamental right. I could not discriminate that between the citizen that you are from the lower caste, you are from the upper caste. So this six seats is only will be available to the lower caste. If I do that, that will be the clear-cut violation of the fundamental right. Then how do I ensure the common good? There is the contradictory statements. If in the constitution only, if I am going to enforce the directive principle of the state policy, that is the provision mentioned in it, I am violating, I am coming in contradiction to the fundamental rights. And if I am ensuring the fundamental rights is preserved, I am not following the provisions mentioned in the directive principle of the state policy. How to solve, how to get the solution. The solution is what we call as the Article 31C that we will discuss. But before we discuss Article 31C, let us go and discuss Article 31A and 31B once again, because already we have discussed this article in the previous video. But Article 31, which says that everybody have the right to property. That means if I am a landowner and I am a zamindar during the British time and I have owned the major portion of the land, so this is my right. I have the right to own this land and nobody can take away from me. But land reforms were to be brought in. So the government passed a law that such as the Land Ceiling Act, and they said that only, for example, 1 acre of land maximum a person can hold. And beyond that, if you are having 10 acres of land, 9 acres will be taken away from you and will be distributed. So that was a clear cut violation against to Article 31. So the first Constitutional Amendment Act came, and we have deal in detail about the constitutional amendment, whether it is a part of law or not. So the Constitutional Amendment, first Constitutional Amendment 1951 came, and they did not repealed Article 31. Instead, they said that okay, if we cannot take away this Article 31, if we cannot take away this fundamental right, we will add a new article. And they said that Article 31A will be added. They said that if we pass some law which violates Article 14 and Article 19, that is, if any law is passed by the Parliament that violates Article 14 and 19, that is fundamental right, should not be struck down by the Supreme Court, because the law will be protected. And they give five categories that we will pass law under these five categories, and the laws relating to these five categories will be protected under Article 31A and shall not be struck down by the court because it's violate Article 14 and 19. Earlier, any law that that violates the articles of the provisions or articles or provisions of the Constitution was struck down by the Supreme Court, but explicitly amendment was done, and the first amendment, that is 1951, created an article, added an extra article to the Constitution, says Article 31A, and which says that saving of laws related to land reforms. It says that certain categories of law from being invalidated on the ground that they violate Article 14 and 19. So laws protected under Article 31A, these are the five categories: acquisition of states or right in the state, जो लैंड रिफॉर्म्स की बात कर रहे थे हम, लैंड रीडिस्ट्रीब्यूशन के लिए अगर किसी का लैंड लिया जाए, abolition of zamindari and all, then taking away management of properties by the state, amalgamation of corporations in public interest, modification of mining rights, and agricultural land reforms. If any law is passed under these five categories, that law shall not be validated, shall not be put to test of constitution on the ground that it violates Article 14 and Article 19. So 2 points should be noted. First, not all the law, not all the law is protected under Article 31A. Only those law which falls under these five categories are protected, and only if they violate Article 14 and 19. So above we have read that the fundamental rights are limited by Article 31A, B and C. This is the limitation. Even if your law that is passed by the parliament violating my Article 14 and 19, that is violating my fundamental rights mentioned under Article 14 and 19, even though these fundamental rights, even if they are violated, the Supreme Court can do nothing because they are enforcing the provision of the Constitution mentioned under Article 31A, which clearly state that Constitution, the law will not be invalidated. That means Supreme Court is doing no wrong. Supreme Court has to follow whatever there is written in the Constitution. But the the legislature at the parliament modified the Constitution and wrote this. Now it's the duty of the Supreme Court protect what is written in the constitution. So they themselves wrote that Article 31A is a new article, and in this they wrote that law shall not be validated. So now Supreme Court will not validate because they are doing nothing wrong but following the provision, the articles mentioned in the constitution. Then also they put another article, Article 31B, and inserted the ninth schedule through this article and said that okay, for this law it is okay. All the laws belonging to this category shall not be validated. Okay, but also they placed that ninth schedule and say that any law apart from this category, if any law is immune from challenge, if in the court, if it violates the fundamental rights. So Article 31A was limited to the violation of what? Article 14 and 19. And what laws? Only the law following under five categories. These can violate. Not all the laws can violate, but only the laws following under the five categories can violate Article 14 and 19. But Article 31B is giving immense power to the parliament. They are saying what? I have make one schedule, added one schedule, that is the ninth schedule, and any law, maybe under any category. If I made that and I place it into ninth schedule, if I write that law, that this law is part of the ninth schedule of the constitution, maybe it be for any purpose or for any reason, that law will not be validated or not be put to the test of constitution, even if it violates the fundamental rights. And no mention of what fundamental rights the law will violate. It may violate any fundamental right. And that's this amendment seems to be little absurd, little vague. And that is why the Supreme Court in IR Coelho 2007, after the basic doctrine structure was put held by the Supreme Court, by the Keshwananda Bharati judgment, he said that laws placed in the ninth schedule after 24th April 1973, that is the date of the Keshwananda Bharati judgment, can be reviewed even if they damage the basic structure. So ninth schedule protection is no longer absolute. Now, I think there would be a little bit confusion. Let me reiterate this and make this very crystal clear at this point only before we proceed further to Article 31C. You see that Supreme Court is the protector of the right. Yes. The only duty the Supreme Court has is to see that whatever is being done in the country is as per the Constitution. Whatever the law is being made is as per the Constitution or the articles or the provision written in the Constitution. Now, the Constitution, the maker of the Constitution has made the Constitution so fair, so just that everything seems okay. But say tomorrow we change the constitution, and why there is a so much roar in the public domain that the constitution is to be saved. They suppose tomorrow constitution is amended and the amendment to the constitution can be done under Article 368. Yes, there is a provision in the constitution itself to amend it. Tomorrow, if the amendment of the constitution is done and all the fundamental rights are struck down. Say hypothetically, it cannot be done because you cannot violate the basic structure doctrine. But before that, suppose Keshwananda Bharati judgment is not yet came. We are talking for the period before 1973. So the Supreme, the Parliament could modify the Constitution. So tomorrow they modify the very structure, the federalism of the Constitution, or say they modify, they struck down all the fundamental rights of the Constitution. So if those rights are not mentioned, they struck it down, they repelled it. If those rights are not mentioned in the Constitution, what will Supreme Court protect? Because the Supreme Court is only limited to what is mentioned in the constitution. Whether it is wrong, it is right, Supreme Court has nothing to do with it. Before the 1973 judgment I'm talking about. So whatever, if even if it is written wrong in the constitution, Supreme Court has to abide by it. It must be followed, and that is what the job of the Supreme Court is. So Article 31A and 31B was a challenge to the Supreme Court, that Article 31A added 1951, Article 31B added 1951. First Amendment, just remember. Article 31A was limited in scope. It says that any law which violates the fundamental rights under Article 14 and 19 and will belong to five categories shall not be put to the test of the Constitution. And right to property was there. It was not struck off in before 1973. 1951 is the date we are talking about. So Article 31B took a step further ahead and they said that 9 शेड्यूल में कोई भी लॉ हम पुट करेंगे, उस लॉ को सुप्रीम कोर्ट को देखना ही नहीं है, shall not be reviewed by the Supreme Court. अब सोचो कि कुछ भी ऐसा लॉ बन जाए और उसको जो है पार्लियामेंट कहे कि दिस विल बी प्लेस्ड अंडर द शेड्यूल 9 ऑफ द कॉन्स्टिट्यूशन और वो किसी भी फंडामेंटल राइट्स को वायोलेट करे, सुप्रीम कोर्ट विल हैव नो से. व्हाई? Because these things are written in the constitution and what is written in the constitution must be followed by the Supreme Court and must be ensured that that is protected by the Supreme Court. The Supreme Court itself cannot do anything because why? Because the things are mentioned in the constitution. Now, that was the debate which took long years from 1951 to 1973, and the courts and the judges they feared that tomorrow anything of such blunder, such disaster could be done, and the court will have no power to do to protect it, to avoid it. So the judgment, why you understand at this point that why Keshwananda Bharati judgment is so much powerful and why it is called the landmark judgment in the case of the Indian Constitution history is because they say that anything you want to change in the constitution you change, but you cannot change the basic structure doctrine. It puts a limitation on it. And then when they defined the basic structure doctrine, they defined that the judicial review is the part of the basic structure of the constitution. And hence, if you want to give the blanket protection to all the laws that you put under the schedule 9, violates the basic structure doctrine of the judicial review and should not cannot be allowed by the court. Therefore, in the judgment of 2007, citing the judgment of the Keshwananda Bharati case, the IR Coelho case, the judges said that the blanket protection shall not be allowed, and if any judgment, any law post 1973, if you are putting it into the ninth schedule, is not free from the judicial review, will be viewed, will be put to the test of the constitution. I hope this makes clear the 31 Article 31A, 31B. Now let us move to what we were discussing in the beginning, Article 31 Clause C. And what is Article 31 Clause C? Article 31 Clause C is basically what we have discussed before with respect to DPSP. That at one hand, DPSP need to be implemented. And if we are going to implement the DPSP, the provisions mentioned under the part 4 of the constitution, we are violating the part 3rd of the constitution. And you will be surprised to know that the harmony between the fundamental right and DPSP is also a part of the basic structure doctrine. I have given you the list, go check it out. So what was the solution? The solution was as many, no matter as many, as long as we are going to make laws for the welfare of the people, keeping in mind the DPSPs, Supreme Court is going to term all the laws as null and void because they are going to violate the fundamental rights. And in the very beginning, you remember when we talk about the justice and equality, we say that providing tool to those who are shorter so that they become equal to those who are taller is not equality but justice. For making justice, you have to breach equality. So for implementing DPSP, you have to breach the fundamental right. So what is the only solution? The only solution is you tell this thing explicitly in the constitution that for implementing DPSP, fundamental rights can be violated. And that exactly what is written in Article 31C. Let's go and just read what is Article 31C. It says that priority to the certain directive principles will be given. Not all the DPSP will be given, but some DPSP which is very important to be enforced, the priority to them will be given over fundamental right. What do you mean by the term priority? That means for the enforcement of, for the implementation of the DPSP, even if the fundamental right is getting violated, we will ignore that because the highest priority is given to this provision of the DPSP. So it was inserted by the 25th Constitutional Amendment Act of 1971, and 31C originally provided what? 31C originally said that if a law is made to implement Article 39 Clause B and 39 Clause C, and we have already seen what is 39 Clause B and 39 Clause C. This is Article 39 Clause B, that the ownership and the control of the material resource of the community are so distributed to subserve the common good. This is Article 39 Clause B, and this is Article 39 Clause C, which talks about the common good, which talk about the common detriment. and talks about the avoiding the concentration of wealth. So if you want to implement these two laws, and even during the course of implementation, if the law violates the Article 14 and 19 of the Indian Constitution, that is Part 3rd, fundamental right, the law cannot be challenged. Okay, so Article 14, 19, the law gets violated under the law made under Article 31A shall be protected. Also, under Article 31C, now we are making laws, nothing related to the all this what mentioned in the five categories, that is with respect to the agricultural land reforms or real estate and etc. But here we are talking about the laws that is related for the enforcement of the directive principle. So if we talk about the law that is made for the implementation of the provisions of the directive principle of the state policy, and if it violates Article 14 and 19, then it shall not be challenged. Okay, so only two directive principles of state policies articles, that is 39B, 39C. If you are enforcing these two articles by making any law, and that law violates only two fundamental rights, article 14 and 19, that will not be challenged. Later what they did, they said that okay, an amendment was made and said that not only limited to 39B, all the DPSP, not just 39B, 39C. So later an amendment was made and it was added that Article 31C, जो कि earlier it was protecting the 39 clause B and 39 clause C. Not only these two articles of the DPSP, सारे डीपीएसपी के लिए, डीपीएसपी के अंदर जितने भी चीजें लिखी हैं उन सभी को इम्प्लीमेंट करने के लिए अगर हमें फंडामेंटल राइट का वायोलेशन करना पड़े तो हम कर सकते हैं, उस लॉ को चैलेंज नहीं किया जाएगा। फिर फंडामेंटल राइट्स का मतलब ही क्या रहा? अगर आप सारे फंडामेंटल राइट्स को वायोलेट करोगे, सारे फंडामेंटल राइट्स को प्रायोरिटी दो दोगे ओवर डीपीएसपी, देन व्हाट इज फंडामेंटल अबाउट इट? So that was exactly what the court said in Minerva Mills case, and it says that ये एक्सपेंशन जो है अनकॉन्स्टिट्यूशनल है बिकॉज आप फंडामेंटल राइट्स को ही खत्म कर रहे हो एक तरीके से। तो फंडामेंटल the balance between the fundamental rights and DPSP is the part of the basic structure doctrine and hence cannot be tampered. Therefore, only two fundamental rights, articles of the DPSP is given priority over the fundamental rights, that is Article 19 and Article 14. So at current position is what? The current position is that the only Article 31C applies only to the law implementing Article 39 clause B and 39 clause C, and it is given priority over Article 19 and 14. I hope this is clear. I hope you are clear that what's the difference between Article 31A, Article 31B, and Article 31C. Article 31B talks about the ninth schedule. Leave that aside. It talks about all the laws, violation of all the fundamental rights. But the catch over here is this law is open for the judicial review. The court will see if the law is mandatory, required, just, okay, otherwise it will be struck down. Article 31A, it says that a law passed for the violation of Article 14 and 19, but the law will only be related to five categories and define the five categories, and then these law will not be struck down by the Supreme Court. Okay. Article 31C said laws made for implementation of 39 clause B and 39 clause C. That these two are the DPSP, directive principle of state policy. If laws made to enforce these two articles and violates the fundamental rights under Article 14 and 19 shall not be struck down by the Supreme Court. That is also okay. So this is the story behind 31, 31A, 31B, and 31C. And then these articles were added, and then 31, Article 31 was repealed, and that we have seen already, that is the 44th amendment 1978. After the judgment came that yes, fundamental rights can be amended in Keshwananda Bharati, but basic doctrine should not be tempered or should not be hampered. So they repealed Article 31 and added them into make that to the constitutional right under Article 300A. They remove that particular fundamental right, Article 31, and put it under Article 300A, that is Part 12 of the Constitution, and made it the constitutional legal right. So, friend, as of now, I have iterated these terms 31, 31A, 31B, 31C so many times that it might seem feel boring, but my only motive is to make you clear, crystal clear, absolutely no confusion, So with these articles, we have not yet started the fundamental right. We have seen the overview of the fundamental rights, their property, what are the different differences in the different provisions of the fundamental right, and specifically we have discussed Article 31A. That is the 31 Article 31 is a fundamental right, but the other articles that has been added to the Article 31A, that is 31A, 31B, 31C. We have discussed that. I hope there should not be any confusion. If there is any confusion, please just rewind the video and watch it. You have to be crystal clear at this point before we move forward and see some more concept on the fundamental right. Thank you very much. The lecture might appear boring, but it is very important for you to understand each and every point iterated by me in this entire duration of the video lecture before you watch the next lecture. In the next lecture, we are going to start with the first article of the part third of the Indian Constitution, that is the fundamental right. And we start with the article number 12. Thank you for having patience and listening to me for such a long time. I appreciate your patience and we will meet in the next video. Thank you. Have a nice day.